In this short podcast, we talk about the adequacy and sufficiency of consideration. The rule is that consideration must be sufficient, but it need not be adequate. What is adequate? It means it would have the same value as the consideration for which it is exchanged. You do not have to have that to find consideration in a contract, but you do have to have sufficiency, meaning the consideration does have to have value in the eyes of the law. And you may have heard of the peppercorn theory of consideration, which is simply in a bargain in which something of value is exchanged for something of even trivial value, such as a peppercorn, the exchange is enforceable. Now, keep in mind that severe inadequacy of consideration may be relevant to determine if there's unconscionability in a contract, but it doesn't preclude a finding of sufficient consideration. Unconscionability is a doctrine that can be applied once the contract is formed. And if unconscionability is found, then the contract is set aside. And the doctrine of unconscionability, along with duress and undue influence, applies to circumstances where a stronger party has taken advantage of a weaker party in the course of inducing the weaker party's consent to an agreement. So unconscionability is where the contract is entered into as a result of inequality of bargaining power, and how you see that is that in the contract itself, you will see a severe inadequacy of consideration. The relationship between the parties is irrelevant. What's relevant is that one party seems to have taken undue advantage of the other. Now, if there's a concluded contract and all the elements have been met, the court may nonetheless find that if the contract is unconscionable, the court may nonetheless set it aside. We may have time to talk about unconscionability in the next semester, but it's important that we know now that unconscionability does not prevent a contract from being formed. Unconscionability rather is something to be used to set the contract aside once it is formed. So let's break this down. What is exchanged for the promise must be of some substance. It doesn't have to be of economic value. It means it has to be value in the eyes of the law. It does not have to be commercially equivalent. Also, the exchange of value need not be the exchange of equivalence, meaning parties are free to make good or bad bargains. The transaction does not cease to be a bargain because one of the parties made a bad business decision. Also, courts are not making your bargains for you, which is why exchange can be nominal consideration. And if you find otherwise, it means the court would have to investigate matters better left to the parties. It means that the court would have to look at every contract and determine whether the consideration in it is of adequate value for what was given in exchange. And that's not the court's role, that's the party's role. So sufficiency and adequacy of consideration. What amounts to sufficient consideration? What does it mean that it has to be something of value, but not necessarily economic value? We're going to talk about that, and we're going to distill what the answer is to that. But before we go on, you may have already noticed that what you'll see in some cases is that whether we can fulfill the rule that consideration exists is sometimes determined by how closely the courts look for it. Basically, you're going to find that a bargain can almost always be found if the court looks hard enough for one. So a lot of these cases are about judicial attitude and many times the background circumstances of the promise. It is also about the contracting party's intentions. So intention to enter into legal relations is relevant here as well. Also, what's important is the judicial attitudes are much of the time founded on whether there is evidence that they can rely on. So all of this is important when you're looking at what is and isn't consideration. In the case of Thomas and Thomas, you see that this is an example of the doctrine of consideration being used to enforce a promise that in all likelihood was actually a gift. So in Thomas and Thomas, the deceased at the time of his death expressed a wish that his wife have the house in which he lived or £100 instead. And the deceased appointed two people, S and D, as his executors, and the plaintiff, the wife, was left in possession of the dwelling house. Now, S and D entered into a contract with the plaintiff, and the agreement was that she should be entitled to occupy the premises during her life or until her remarriage, in return for the making of an annual contribution of £1 to the ground rent of the premises. Now, after one of the executors died, the other one wanted to eject the plaintiff out of the house. And the executor argued that the plaintiff had given no consideration for being able to stay in the house. That rather, her being able to stay in the house was simply her husband's wishes, and it was not part of a contract. And the executor argued that the deceased's wishes are irrelevant to the contract, are irrelevant and do not form a contract. And the court found, first of all, consideration means something of value in the eyes of the law, moving from the plaintiff. We have to find something moving from the plaintiff. The court found that the deceased's wish to benefit the plaintiff does not constitute consideration. A wish is merely a motivation. In the will, the deceased had also said, you get to live in the house until you pass away or until you remarry. And the court found that a promise not to remarry is not consideration. What this is a condition that terminates the agreement, which is a condition subsequent, meaning you have an agreement, and if something happens which is stipulated, then it puts an end to the agreement. It puts an end to the existing obligations. Contrast this with a condition precedent, which is something that has to happen in order to bring into existence a legal contract. So the court found that here the valuable consideration is the £1, and said that this simply isn't a burden that was incident to the assignment of the property, but rather it was a different obligation that could constitute sufficient consideration between the plaintiff and the executor. So think about this. First of all, let's note that had Mr. Thomas given Mrs. Thomas a right to live in the house in his will, there would be no issue. But he didn't, which is why we have this problem. So she didn't have a will. She had to use the device of a contract to enforce her claim. And we should be thinking here about what the court's real reason was in upholding the agreement. The practical aspect of this is it shows you exactly why nominal consideration is sufficient. If courts were to concern themselves with identifying and quantifying the element of consideration, and whether promises made for nominal consideration could be gifts instead of bargains, there are too many difficulties. It's too much for the court to consider. Another reason, however, that the court will sometimes give effect to nominal consideration is actually to uphold the party's intention. Here the court was moved to protect Mrs. Thomas and found a basis for doing so in her promise to pay the executors £1 yearly. The existence of the obligation to pay the rent and her acceptance of that obligation doesn't transform a gift into a commercial exchange, but it does give the court a peg to hang its decision, which was entirely motivated to protect Mrs. Thomas. Now, one other factor to consider here is the law regards agreements between spouses in a slightly different way than between commercial parties, and it gives more flexibility to agreements between spouses. We'll talk more about that as well. Now, this case is not an ideal example for finding consideration, but it is a good one for seeing that there are factors that influence judicial decision-making and lead judges to find a contract in certain circumstances where it may not be entirely obvious that there is one or should be one.